Yeah, Vikas, you can.
Okay, so good afternoon. I welcome you all to the first session of the Legal Services Month 2021. Today's panel discussion theme is Responsibilities and Liabilities of Independent Directors. It is my privilege to welcome the guest speakers of the session. We have with us Honorable Justice Shri Rajiv Handlaw, former Judge, Delhi High Court, Mr. Rajesh Narayan Gupta, Managing Partner, SNG and Partners. Mr. Gupta has also kindly consented to moderate this session. Mr. Shailesh Haribhakti, Independent Director on many reputed boards. I think Ms. Ranjana Roy Govai, co-founder and managing partner, RG and Associates, would be joining us soon. And Mr. Sundareshan Jayamurthy, board strategist and compliance guru. And of course, Dr. Lalit Bhasin, Chairman CII Task Force on Legal Services and President SILF. Thank you all for your time and for joining this important panel discussion. And we are indeed looking forward to a very interesting panel discussion. Before handing over, I would like to make two observations. I was talking to a very senior veteran legal luminary of the country the other day, and he mentioned during that conversation that he used to hold around 10 independent directors positions some time back, and now he has resigned from all the boards except one. For him, this is because of the liabilities and the obligations attached to the position, and he doesn't want to carry any risk or get bothered by a legal notice. The point to ponder is, are the laws of the country getting so complex that they instill a fear in the minds of the professionals and experts to take up positions? Is the seat of independent director so onerous that people seek more risk? People see more risk than reward in the position? And if the above is true to some extent, doesn't this make an impact on the workings of the corporates, the integrity, transparency, and governance of the boards, safeguarding the interests of the shareholders and other stakeholders, and ultimately the image and ratings of the country by the world governance standards? Another important point which keeps coming to us is how independent is the independent director. The issue of remuneration, ESOPs to be granted or not granted, the dependence on a particular company if the person holds independent director position in that single company. These are few of the issues of deliberations, and I am sure there would be many more. Welcome, Ranjana Roy Govai, co-founder, managing partner, RPG and Associates. We are just starting the session, so thanks for joining in. So these are the issues which I thought that I would bring to the table as a curtain raiser and then just to ponder upon. I am sure there would be a lot of other issues which of course will be discussed during this interesting panel discussion. So with these remarks, thank you all once again for joining, and may I now request Dr. Bhasin, you'd like to make few remarks and then hand it over to Mr. Narayan Gupta. So over to Dr. Bhasin. Thank you.
Yeah, thank you, Vikas ji. Firstly, you see, I must compliment CII and also Mr. Vikas Mohan, who is the executive director of CII, for agreeing to institutionalize this Legal Services Month, which we have been celebrating under the auspices of CII since last year. That was a unique success. So we wanted that to be repeated this year also. So we have put in place about 12 or 13 webinars on important topics pertaining to business laws, financial laws, because we as members of the law firms, as lawyers, we are essentially business lawyers. We advise, you see, the corporate bodies, the multinational companies, national companies, big business houses. So since it was a big success, we decided to have it this year also. And today is a very auspicious day to start because today is being celebrated as Legal Services Day all over the country. And We are starting, you see, this series of webinars on this day today. That also in the distinguished presence, you see, of so many legal and professional luminaries. I would not say only legal, because we have really celebrities like Mr. Shailesh Hari Bhakti and Mr. Jayamurthy. But before we do that, we must acknowledge the presence of Honorable Justice Endlaw. I don't call him, you see, just a judge. I have seen him actually grow in the profession also, then being elevated as a judge of Delhi High Court, which position he held with great merit, and his role was acknowledged. I'm not in the habit of introducing judges, because the judges, their judgments, they speak for the judges. It is not what they have done in the past, what they have done. It is what they have done as a judge. And Justice Endlaw's record, if anyone looks into the law reports, I think it is a endless thing of putting in his entire knowledge, his commitment, his versatility in the field of law into the judgments which he has delivered, particularly under the corporate laws and the dispute resolutions. And so it's indeed a privilege to have Justice Endlaw here. Our moderator or the chair of this is Mr. Rajesh Narayan Gupta. He's one of the most eminent uh, lawyers in the country, heading one of the best law firms. It is not just one of the ordinary law firms which we find at the drop of the hat. He's done tremendous job, and he's a great author. Just last month only I received one, two, three, 4 volumes, 4 volumes of his treatise on banking law and practice in India. Huge volumes of 1,000 pages each. And that is, you see, the type of caliber that our chairperson today has, besides heading his very distinguished law firm, that is SNG and Partners, having offices in Delhi, Bombay, and other places. So we have, from the corporate world, I would say, although he's a very reputed chartered accountant, that is Mr. Shailesh Hari Bhakti, but he does not belong just to that profession. I think the service which he has rendered to the corporate world has made him quite apart from just being a chartered accountant. He's in his own right, you see, a corporate leader, advisor, and I have had the distinction of being on the board of some companies along with him, and where we had seen his acumen uh, in the field of chartered accountancy, in the field of financing, advice to the board. One of the most distinguished and very active in the Indian Merchants Chamber and other organizations. So it's a privilege for me to particularly welcome Mr. Shailesh Hari Bhakti. Ranjana is, you see, someone whom I would say she heads a young law firm, being young herself. I can call everyone young, you see, because after putting in 6 decades in law practice, I think everyone I can call young. But she is really young, but her firm, I can't call it emerging law firm, because in my opinion, it has already emerged. Her law firm, which was set up a few years ago, I have had the privilege of knowing her and also pushing her into, to doing something for the society by participating in these events and sharing her knowledge and expertise with all of us. So she heads, you see, one of the very good emerged just emerged law firms, and I think that firm will do a great job in future also. Wish you all the best, Ranjana, and thanks for joining us. And then we have someone who, although younger to me, but still he's called Guru, So I have to call him Guru. That is Mr. Sundareshan Jayamurthy. What is he known as? That is the reputation. What is the reputation that he has gained in the corporate world, being a company secretary of great distinction? He is called a board strategist and compliance guru. So I think the corporate world relies very heavily on his expertise, his knowledge, his competence as a board strategist and also compliance guru. It's indeed a privilege that we are starting this series today in the distinguished companies of so many luminaries here, whether in the field of law or in the field of accountancy or in the field of board management and in the field of law. Just 1 minute only on the topic, because I know I can speak for hours on this, having been on the board as independent directors on so many companies, including the one which we shared with Shailesh Bhai and Reliance and all that. But one question which was made by Mr. Vikas Mohan also in the passing, but I would like to stress upon it. That is, how independent are the independent directors? Are they really independent? Because if they are not independent, then the question of their liabilities and responsibilities, you see, would be identical to those of the other promoter directors or other people. So what makes them different from the other directors who are promoters? In my view and in my experience, I don't think it makes much of a difference so far as the practical side is concerned. Independent directors are nominated by the promoter directors who control the affairs of the company. They get the resolutions passed, you see, from the board to get them appointed as additional directors. Then they are through the shareholders, which again are the promoters. Those independent directors, you see, are made regular directors. And that is when they become integral part of the board of directors, but as non-executive independent directors. But in practical terms, what does that mean? The decisions are taken, the policies are laid down in the board meetings, and independent directors are always a part of it. Therefore, the question which arises for consideration is that when we are discussing the responsibilities and liabilities of independent directors, this question will inevitably arise. That what is the mode and manner of the appointment? Because supposing the promoters are not happy with some independent director who decides to take some independent view. So in the next, you see, after his term is over, he will not be nominated again. Someone else would come in his place, his or her place. So these are the issues, and I would like, beside the question that the panelists will be asked, if these aspects can also be touched upon very briefly. And now with this, I have great pleasure in handing it over, you see, the entire proceedings of this webinar to my dear friend and colleague, Mr. Rajesh Narayan Gupta. Over to you, Rajesh ji.
Thank you, Dr. Vasim, for all your kind words and also for putting a base to this entire conference. Thank you, Vikas, for your initial comments. We'll see how we cover the issues raised by you and Dr. Vasim during these proceedings. All of us know independent directors are expected to play a neutral supervisory role. Now, owed to various lapses and frauds, the role and responsibility of independent directors has enhanced many folds. At the same time, the liability has become severe. Independent directors are expected to play a significant role in all possible aspects today. It could be audit, it could be appointment of key managerial personnel, strategic decisions, risk management, internal control, protecting interests of minority shareholders, etc. So in this background, let me start this with Shaileshwari Bhaktiji, and over thereafter we'll move, to all the panelists one by one. So, Shaileshwari, all of us know you are handling so many boards, and you are non-executive chair to so many boards. So, in your experience and judgment, what are the expectations, first of all, from an independent director under the current laws and practices?
Thank you very much, Rajesh Bhai, and thank you very much, CII, for having all of us come together on this marvelous panel. And what a great question to start off a seminar on independent directors. The expectation of the law, as you are aware, all of you are aware, is enshrined in Schedule 4 of the Companies Act under Section 149(8) of the 2013 Act. And if I analyze that schedule, it tells me that the expectation from an independent director is certainly to be independent, as Lalit Bhai pointed out. It's very important that you have a fiercely independent stand on the board. You should feel free to ask the right questions, which has become the biggest remit of independent directors. And in an emergency, the Schedule 4 really places a huge amount of responsibility and power in the hands of the independent directors. We have seen several instances in corporate India where independent directors have asked for massive changes, including the change of a promoter chairman of a company, as we saw a few months ago. And so the powers and responsibilities are widespread. And in my view, India is the only country which has this kind of extraordinary importance and role definition under the law given for the role of the independent directors. Now let us take the way the world is evolving. This morning, I spent an hour and a half listening to a webinar on decentralized autonomous organizations and how these are going to completely transform the pace of innovation in our world through NFTs and FTs and digital metaverses, and how we are going to experience in the next 6 months far more innovation than we have experienced in the last 10,000 years. So what is the governance mechanism that a DAO should have? It's very interesting. What is being thought of is to provide everybody who has an economic interest in a DAO with what are called voting chips to vote on every resolution where there is a fork of two choices to be made. And the independent directors or the directors of this DAO are empowered to make sure that they will mutually agree on the course that needs to be taken through the mechanism of these NFTs, which will enable them to vote on them. So think about where we are. We have all this empowerment, appointment, all of this, to a situation where there is this decentralized, completely autonomous organization, fully digital, and you are empowered with these chips. And what you are enabled to do is vote. So Rajesh Bhai, to answer your question, I think the three expectations from independent directors are to be fiercely independent and ask the right questions. Two, to make sure that the course chosen by the company is the most appropriate course, given all the circumstances and given all the knowledge, wisdom, information, data access that is today available to independent directors. And lastly, and perhaps most importantly, to be the final custodian of the sustainability of a company in every which way that you want to think about it. whether it is environmental stewardship, social responsibility, purposeful governance, greater productivity, uh, major efficiencies. You take any big thought that is ascribed to boards and to management of companies at that level, it becomes the responsibility, the collective responsibility of the board, of which independent directors are a very critical part, which is enshrined in our law.
Very insightful. Thank you very much. But let me continue with you, so to set the right pace to this program. Now, in well-managed company and boards, as you would experience, you are given with all possible reports, the business plan, the audit, the reports of internal, external auditors, what is going to happen in the company, not going to happen in the company. You also get your compliance report. The company secretary department, they sign all possible compliance reports also. A lot of comfort is given to the independent directors that everything looks good. Now, independent directors are there for 3 or 4 or 5 meetings in a year. And they've got all these armed ammunitions, all these reports coming from all possible departments. So in your opinion, what more should we look for? What an independent director should ask more from the company just to see that there is no fraud being played or he is fully equipped to handle these meetings?
Again, Rajesh bhai, very insightful and very important question. Let me share with you what I rely on.
Yeah.
I am extremely keen to create the right kind of moral suasion and moral capital-based relationship with the executive suite. And that is, to my mind, the most critical responsibility of an independent director. Because if you have that moral capital, then you will be empowered to ask the questions from whoever, at whatever time, not at the board meeting alone, not just by looking at the documents, but insisting on, let us say, a visit to a plant or a visit to a facility or an interaction with the legal firm such as yours to get insights into issues which are complex and which are fraught with multiple interpretations. And that empowerment has to be felt, it has to be given, and it has to be exercised. If you have those abilities and that freedom given to you by the chairman of the board and by the way that the board processes are structured in a company, and again, where I'm the chair, I go out of my way to make sure that every board member feels so empowered, to make sure that they can interact with people in the interagnum. We have very high trust in our board members. If we do not trust the board members, just don't have them. We use the annual appraisal of board members and of committees in a very powerful manner to embolden, to empower, to judge, to further tweak the responsibilities and the contributions of the directors. And when you bring all of these things together, then you have, beyond the data flow, you have the relationship flow, and you have the getting under the skin of the business model kind of idea, which drives the true contribution of an independent director. It is still not a foolproof antidote to fraud or to malpractice or to doing things which would make the independent director feel ashamed or concerned. So there is no antidote and there is no guarantee. But if you are diligent and you are empowered and you exercise that empowerment, then there is a better chance that you will prevent fraud from happening. I would also like to end by saying that digital processes have enabled us immensely. The entire compliance role, and we have a compliance guru here, so I should defer to him on this subject, but the way in which we have been able to digitize compliance is of an order of magnitude, and it is improving every day, that I have not seen before. And when you get the best extracted version of a fully compliant report, then you get the satisfaction that you have done your diligence and have been true to your salt as an independent way.
Thank you, Shailesh. I'll come back to you, but it's very, again, insightful because as per you, the board member should not just confine himself to the boardroom. There's more to do, more to interact with the executives, more to look at the business and do many more things outside the boardroom if he really wishes to analyze the functioning of the company very, very well. Sudarshan, let me come to you now. As Shailesh said, let's start, go to you next. You have been watching the functioning of the board so closely. So what are the common failures on the part of independent directors? We have cases like, say, Satyam, Enron, ILFS, etc. So what is your experience on that? Can you share your experiences or insight on this?
Okay. Good afternoon to all, and thank you, Rajesh and CII, for having me. First let me start with a disclaimer, Rajesh. Because you will find me throwing up a lot of case laws, and which are in the print media, of course. But when I give you the names of companies, I should be careful. So the first disclaimer is very clear. The observations that I'm making is based on news in media, and I'm not privy to any board matters inside these companies. The second disclaimer is this is a general observation and it is not applicable to all independent directors. So with that, I want to start because
yes.
I don't want to offend any independent directors, because the question that you have asked me is very sensitive, is very complex.
Yes,
so
I appreciate.
Very practical in what I'm going to tell you. So first let me start with two recent news, which itself is contradicting. Okay. First news is Supreme Court has come out and said directors cannot be booked just because company has violated law. Now the headline in the media looks to be very funny, because all these years we have known that a company is an artificial person. So if you are not going to book a director for an offense, who else are you going to book? I don't know. You can't arrest a company. So looks like, every day we have some differing judgments and news in the newspaper. So I'm just giving you something which has come out recently in the news. But I would give this news a 10 brownie points for the only fact that it has come out with a zero liability vaccination. Now that's another new vaccination that I'm talking about, which is for all the directors. It's come out with a zero liability vaccination. Is it true? Is it possible? I don't have an answer for that. Let me just move on to the other news. The other shocking news is the arrest of Pradeep Chaudhary. Now, on one hand, Supreme Court says directors cannot be booked, and on the other hand, they have ordered the arrest of Pradeep Chaudhary, who was an ex-State Bank of India chairman. Now, look at this funny case. Lot many directors will not even get onto boards, actually, Now, this poor soul had actually come out of State Bank of India. He went through the cooling off period for 1 year, and then he joined a company called Alchemist Asset Reconstruction Company Limited. And the case which was filed a few years back, suddenly it got decided recently. And since Pradeep Chaudhary is on board of Alchemist, they said arrest Pradeep Chaudhary. Now, these are two instances I want to place before the audience and to the panelists. Please try and decipher these two cases. Both are so contradictory. On one hand, I'm not going to arrest. On the other hand, I'm arresting someone who was not even involved in the crime. Okay. Now the question that you asked, you said Satyam, Enron, ILFS. Now Satyam 2009, ILFS 2019. So we are talking about a 10-year gap. Okay. And Rajesh, let me tell you, these two cases that you are talking about, very funnily, the media says it's a corporate governance failure, but I vouch what Shailesh has said. These are frauds. So I think clear distinction has to be made between a fraud, corporate fraud, and one which is called the corporate governance failure. Now, what is a corporate governance failure? Indigo may be a corporate governance failure. A Tata Sons in 2006, that is Cyrus Mistry Tata Sons, can be a corporate governance failure, but not Satyam, not ILFS. Okay, so these distinction, I think my friends should understand that you need to dissect every case and figure out if it's a case of fraud or case of corporate governance failure. Fraud, I don't think independent directors can be hanged, because even auditors, I mean, pardon me, Sailesh, even auditors sometimes fail to see fraud. So independent directors, I think, is not an institution to be hauled up. Okay. Now, why are these failures? Now, you asked a question, what is the contribution? What are the failures that I can see? Of course, with about 100 cases that I have studied, I will just pick around 4 for you. The first one, it is fear. Please understand, it's fear. Fear is the key. And that case is ILFS. The second factor of failure for independent directors is price of cowardice, which is being cowards. I would say Jet Airways. I will explain each of this, but I'm just trying to decipher this into 4 buckets so that, of course, I can't discuss more than that, but I'm just giving you 4 points. The third is independent directors are getting tagged as CEO's accomplice. Now, please understand, there is a big difference between being a CEO's friend and being a CEO's accomplice. S-Bank is a classic case where independent directors failed to understand what was going beyond Rana Kapoor. Now, lastly, I want to discuss something which is on the powers of suggestion. Now, this is a very serious thing which is happening inside corporate boards, where actually independent directors are falling for this, which is called powers of suggestion. And one such case is Tata Sons, where, of course, personality does matter in this country, but can personality get even celebrity independent directors like Venu Srinivasan and Ajay Piramal to commit mistakes? I leave it to the audience to decipher. But 4 cases that I can think of is fear, cowardice, CEO's accomplice, and powers of suggestion. Now, why is this thing called fear? Fear is the key, right? Now, please understand, all independent directors are not billionaires. That is the problem, right? You find that independent directors come from a middle or a higher middle class families. So what is the problem? The problem is when they are joining companies, they want to create some difference for themselves and to the company. After the first year, they start embracing their position. Second year, they start loving their job. Third year, they start becoming friends of promoters. You understand, no? I mean, all the frills that comes in being an independent directors, I think independent directors know that better. Fourth year, they see the glamour in the profession. And fifth year is when the fear factor comes in, which is the fear of getting reappointed. Now you understand where the fear is coming? So this is how the cycle, the cycle of an independent director moves in this current scenario, and that is where they're fumbling and falling. So what is the takeaway from the first point? Very simple. Please be bold inside the boardroom, even if it means you are not a billionaire. You have to stand up and fight. Okay. Second point is price of cowardice. That is what we saw in Jet Airways, where independent directors started resigning one after the other. Agreed. I am not saying it is wrong to resign, but one after the other would mean there are nobody left in the company. But here I would like to bring to the attention of this audience, are these independent directors losing the natural talent of being inquisitive? Are they lacking this thing called digging deeper into certain things? The reason is over a period of time, I think the institution is becoming more guarded. They become more self-protecting. They start calculating the, pardon me, perks. So what is happening is it is becoming a natural process. And what is getting lost is the job of protecting shareholders' interests. So the second point, very simple, is price of cowardice, which is not standing up and fighting a real battle. Okay, whether we are paid for it, I am not getting into it because you asked for an analysis. I'm just giving you the 4 different points. Now, what is the root cause of cowardice? Very simple. It's the herd mentality. Now, herd mentality is what exists in many boardrooms, which is all the directors look at the lead independent director. If the lead independent director says yes, I think most of them play the ball. Nobody wants to really go against the wishes of independent director. The third one is, of course, the most happening thing, which is independent directors becoming CEO's accomplice, which is classic case of S-Bank, CG Power, DHFL. I mean, you name any of this. Now, what's happening is these 5-6 independent directors versus a CEO inside a boardroom. Now, what's happening? Whatever the CEO is trying to sell, the independent directors are buying it. I mean, if you want me to cite more cases, there are huge number of cases. The classic case is of Hewlett Packard, where they had multiple CEOs before appointing Meg Whitman. Imagine, it is like 5 CEOs before that person, after losing billions of dollars in bad acquisitions. So CEO's accomplice is not the way going forward, is my take. Of course, I have a lot of other cases like Cisco, Intel, IBM, Nortel. I mean, you have n number of international cases and Indian cases. So be a friend to a CEO and not an accomplice. And lastly, the one which I want to bring home the point why things are failing inside boardrooms are the powers of suggestion. Now, what is this powers of suggestion? Very simple. When something is proposed, many times people fall for it. It is just the 70 screen where the proposals are put and where the CEO and the management proposes. And that's where, based on that suggestion, people fall for it. So my suggestion is, please look at the largest bankruptcies which has happened in the recent times, including Videocons, SR Group, and so many other companies, right? Which is all lying before the IBC. Now, these are all the resultant cases of powers of suggestion, which is, I need to borrow more money, more money, more money. And finally, I don't think people are looking at it and people are falling prey to such traps. So listening is good, but please do not fall into a trap. So these are the 4 observations that I have, Rajesh, which are actually between Satyam and ILFS, which has costed the country few lakh crores of money. And this primarily I would attribute to the failing of independent directors. Yeah.
They're very useful, especially the distinction you made between the fraud and the failure of corporate governance. So that is where, when we come to Rajivji, we are going to ask him that how you determine that and how you talk about it, because that really makes a huge difference. Not only the principles of these 2 issues, but also on the position of an independent director in a company. Because, a lot of good and bad things happen when such events break out. And there are a lot of fallouts. And I have to come back to you, Sundarshan, on the issue of appointment of directors also, an issue raised by Dr. Liabilities Bhasin. But before that, Ranjana, let me come to you first. Now, as a practicing lawyer, you are defending many independent directors and KMPs, as I understand, in certain situations where there are alleged frauds or problems in the company. So, Ranjana, what are your suggestions to the independent directors, how they should be shielding themselves against possible acquisitions like this? Because these acquisitions are not simple. They can, first of all, implicate you in civil and criminal matters, but from reputational issues also, the whole reputation suffers if the independent directors are involved in such legal issues. And today, with the power of print and the media and the WhatsApp, I think it's just a click of the mouse and the whole reputation gets shattered. So any suggestions from you, Ranjana, to the independent directors?
Surely, Rajesh, before I come to that point, first of all, let me just thank Justice Rajiv Sahai in-law, who I happened to be, part of one litigation long time back as a junior lawyer. And then, of course, what Mr. Bhasin said about Justice in-law is absolutely correct. We've seen him, imparting justice, writing judgments without getting influenced by anything. So, and we also thank CII for bringing me in along with these eminent personalities like Justice in-law, Mr. Bhasin, Shailesh ji, and Mr. Sundareshan. And I also thank Vikas ji for inviting me in this session. Rajesh ji, as a practicing lawyer, we've been saying, I've seen all those suggestions, which is very valid suggestion given by Shailesh ji and Sundareshan ji, which is absolutely apt. But the question which you asked me, that what should be the protection, mechanism, how they should act in a manner whereby there is a very limited liability and they are not exposed to all either criminal liabilities, vicarious liabilities, or any civil liabilities. See, if we see the section itself, the definition itself, where what is the role and responsibility of independent directors? It starts from section 149, coupled with Schedule 4, which Shailesh ji has already said. And if we remember all those things, then I think we can minimize our exposure towards all those liabilities. Am I audible?
Yes.
So, so therefore, if we see the very definition, what should be the role, how we have to act. If we remember all that, what Hari Bhakti ji and Sundareshan ji said, if we remember that we have to be very active. The law itself has given us a power to record our dissent. It should be through board processes. If I am not agreeing with the promoters or the majority of the directors, those who are actually in control, and they are responsible for running of the business in terms of the section itself. And if I'm not agreeing it, then I should have a courage to get it recorded in the minute. And if it is not recorded, then I have got a separate means. I can write to them that, look, this is how it should be. This is the mechanism which should be. Because ultimately, what is the role of independent director in a company? Section 166 of the Companies Act is very clear. The interest of the company is paramount. Why? Because it's not only the promoters whose interest has to be protected. It's the interest of all minority shareholders, other stakeholders, public shareholders, public funding, banks, etc. So how to do it? Because promoters will always look after their interest. They want to remain in the management because ultimately they are controlling the company, they are exercising the power. So therefore, what is the mechanism? The mechanism has been brought in a listed company. If it is unlisted company, but then the market capitalization is more, or the turnover is more than 1,000 crore, then what should be the role of the independent directors and how many numbers of the directors should be there? That's a functional part. When coming to the liability, so three things we have to remember. Even if we are not part of, independent directors are not part of the day-to-day affairs of the company, or they are not controlling the company. However, they are the watchdog to see whether the company is functioning properly or not. So how to protect it? As Sundareshan ji pointed out, these judgments, recent judgments. So there are two judgments which are contradictory. One judgment is Gitanjali James, where Justice Nariman pointed out that the nominee directors or independent directors should not be fastened with the liability of the fraud, because the fraud will always come in a layering. It's impossible to detect the fraud, and we are also part of the society where all kind of people will be there. Answer is not only the Tatas or Birlas and all those where they ensure that there is no fraud. There may be failure of corporate governance, but they ensure that there is no fraud. At the same time, there are various companies where frauds have been committed. It is detected either through the public forum or someone through the mechanism of the government, like Serious Fraud Investigation Office or Enforcement Directorate, where they'll find out that if there is a complaint, whether it is a genuine complaint, if it is not a genuine complaint, That is the one aspect. So therefore, we have the independent directors or a nominee director has to be very clear. He has to ask for all possible information. If the information is not given, then they have to put it there that these are the information which is not given, because the power as provided under the Companies Act or LODR or a SEBI Act is a great power given to all these independent directors. So they have to exercise their power in a manner so as to protect the company first and also protect themselves. So these are the two important points. And how will they protect it? I have already pointed out. They have to be very upfront. They have to ask the questions. They have to take all kind of a possible questions with respect to a balance sheet, because they independent directors are ultimately, they are the majority on the committee, various committees, which includes the audit committee, which is the most important part of the running of the company, because that actually talks about finances, how it is managed, how it should be managed, whether you are managing it properly, the loans which you have taken, whether it has been utilized for the purposes of for what the loan has been taken. So all these things they have to ask for it. If they are satisfied, well and good, then the resolution can be passed. If it is not given proper answer by CFO or majority of the directors, then in that case, they have to record it. That is the mechanism they have to involve. Not only that, under the Companies Act or under the SEBI Act or SEBI LODR, they have got even a power together to go and ask for filing the complaints before NCLT or before SEBI, saying that, look, I'm acting as a whistleblower. Why? Because these are the informations we are wanting to know. They are not providing it. And if we do not do, then there is a possible fraud. So we are trying to prevent that fraud. For that purposes, these are the rights and the powers they must exercise just to avoid any fraud. I mean, we have also seen many frauds. These are what the aspects where they can prevent themselves. Now I'm coming to how the courts or how the authority should also behave. There is no particular parameters where, the particular judge will act. There are no guidelines. For that, a very important judgment of our on Delhi High Court, courts of its own motion versus CBI, where it laid down certain criteria as to when arrest should be made and how it can be stopped. And then that guideline was put in before all, subordinate judiciaries. Today, if something happens, we show the judgment, and then the bail is granted, or, if any arrest is made, they ensure that whether it falls under that, whether it was required. So all of that should also be done. There is in 2020, there was a circular issued by the Ministry of Corporate Affairs, which says that those officers in default only be responsible if there is a sufficient evidence, only when the independent directors have not acted diligently, they have not asked the information. If they have connived with the promoters, only then they should be arrested. But what happens is, generally, if there is an investigating officer, they'll make all the board's member, including the independent director, without examining whether actually they have committed any fraud, whether they were party to it, there was acquiescence, consent, etc. If it is not, then what are the steps to protect the independent directors? And that step is, according to me, the Uday Kotak's recommendation, which has been partly implemented. SEBI especially has implemented most of the recommendation, barring few, because part of the industry, out of 49 or 50 recommendations, majority of the recommendations was passed unanimously. Many of the recommendations was objected to by the industry itself. They said that we are not going to do the business. So therefore, those got modified and few of them got dropped. So these are the important aspect. And for court also, they have to see that even if suppose the person has been made accused in the criminal liability or the civil liability, then what should be the criteria? The criteria has not laid down now. Criteria has been laid down by Supreme Court, because the NIA Act is one of the oldest act, Negotiable Instrument Act, where generally checks used to be signed, and if there is a bouncing of the check, then the complainant will make whole of the board as accused. So then the matter went up till Supreme Court. Supreme Court laid down, no, you have to see triple test. The first is, what is the time of commission of offense? Second is, who is responsible for those acts, and who is looking after the day-to-day affairs of the company. So these criteria. Subsequently, that criteria got changed in recent times in 2014, and then it was drawn to twin test. That who is responsible for the day-to-day affairs and whether the person is in charge of that company or not. So these are the two tests. This is also applicable to independent directors. This is what is the latest judgment of the Gitanjali Gems, where Justice Nariman has laid down the law and said that no, everything cannot be, it is a fraud because fraud can be daring. It's not necessary that even the auditors can identify the fraud. This is what exactly happened where there was a complaint in the SEBI in that Price Waterhouse Cooper, and recently SEBI has passed a judgment in favor of one of the auditors of the company. I mean, partners of the auditor, TLI, and they held the same thing. If it is in a layering, how it is possible? Because the auditor is also not looking after day-to-day affairs of the company. He is relying on the information given by the CFO, and CFO is the one who is into day-to-day where the money is coming, whose money is given, and all those information. If it is done in layering, then it's impossible to detect. Therefore, the auditor will also not be responsible. Same principle is also applicable to independent directors and nominee directors. Very interesting matters, which I will not name it because the matter is pending. But in that matter, investigation done by SFIO runs into 108,000 pages, and 287 people have been made accused. Includes independent directors, includes nominee directors, and they went rushing to the court for the quashing. Quashing has ultimately been done in favor of all those bankers' nomination, saying that how in the investigation report itself, it is not shown that what is the evidence against them that they can be made part of the fraud. So therefore, the investigating agency should also be made mindful that who should be, until unless there is a circumstances with a very strong evidence suggests that the person is responsible for the fraud, they should be held liable. So these are my take on that. And,
thank you, and thank you. It's very useful, very insightful, and one important takeaway is the independent directors, wherever they need to refuse or object, they should do that immediately, and they should, because they always get minutes, draft minutes to respond as well. If their objection has not been recorded, they should record it there. And I have witnessed a matter very recently where these observations made by independent directors in writing saved him, because he had raised that objection which he was expected to do. Thank you so much. And let me, I have one or two very quick questions to ask Sundaresh as well, but let me first go to Justice Enlaw. So, sir, you have heard a leading chartered accountant, a leading company secretary, and a lawyer. And some data is there with me, a published data which says in 2018, a total of 767 independent directors resigned. In 2019, the number was 1393. In 2020, it was 1344 for listed companies alone. So there's an expectation from independent directors to perform in a particular way, and then there are rigors of investigating agencies and the law. So, Justice Enlaw, in your opinion, where is the balance? Like, what kind of balance the investigating agency, judiciary should be looking at to promote this institution of independent directors? Because if at the drop of the hat, like Pratik Chaudhary's arrest happened, then suddenly the independent director is running away and not in a mood to join the board. Over to you, sir.
Thank you, Rajesh. As far as judicially is concerned, this area is quite a virgin territory. There have been hardly any adjudications about liabilities of independent directors. Whatever judgments the other panelists have mentioned, all these judgments are in the context of a director, mostly. There may be a stray observation here or there about independent director, but they are dealing with the liability of a director for the offenses which are attributed to the company. So I would like to, that gives me an opportunity to share with you that the way I as a judge would have considered, because you see the situations can be myriad. There can be different facts in each case, but judicially the way the judges are trained to look at it is, we always go into first that what was the mischief which was sought to be prevented. See, this independent director is not a concept which is natural to a company law or which has always been in existence. Independent directors is comparatively a new creation. So, in my opinion, the logic behind creating this office of independent director, in fact, when I was thinking, that simile came to my mind. Rudyard Kipling said that God could not be everywhere, so he created mothers. Now, a need was felt. See, it's not for all companies that an independent director is provided in law. It's for certain companies about which the legislature felt the need to provide some vigilance to protect the interest either of the public or of the government or for laws compliances. So only vis-a-vis those companies, a provision was made to have independent directors. Now, while answering this question, I'm not going into the question of whether the director is independent or not, because that is a given when we are debating the responsibilities and obligations. So we are proceeding on the premise that the director is independent. Now, what you mentioned about such large-scale resignations being submitted, I was in fact, for every talk you have to prepare a lot. So that's how each talk enriches you. So I was studying on the subject. Then I had the number of Miss Gawai. So I thought she is the expert. So I had a chat with her and we exchanged views. So she also mentioned that there have been these large-scale resignations and there is a fear. And I told her that at the beginning of one's career in the profession, a client whom you have been handling for 10 years, 15 years, they would invite you to be on your board. And you unthinkingly, because in 10, 15 years, you have built such a relationship. So I was also like that on the board of two of my clients. And what now when in retrospect, I was thinking, I was hardly competent to be on the board. I am not a person who's equipped or who is skilled to read a balance sheet even, lest audit reports or anything like that. So what I imagine that a large number of appointments of independent directors happened when people walked in unknowingly, when slowly they started realizing that what are the obligations and what they are required to perform and the difficulties which they are requiring in performing that. So that is the cause. The cause cannot become a reason for saying that the office of independent director is bad. The office of independent director has been created by the statute and it has to be complied with. Now, how independent directors are to be found if none are available, that again is a big subject which, according to me, we don't have time to debate today. Now, what you said about this thing, see, it is not as if it is at the whim and fancy of anyone to start prosecuting an independent director. The law has very well laid out tests of whether the person who occupied the office of independent director took due care and diligence, which under the statute he was required to undertake. Now, due care and diligence is not something which can pose a challenge or which can be so difficult because it is a very well understood term in the legal parlance. So there are well laid out tests in various judgments that what is the level of due care and diligence. What Ms. Gawai mentioned about layout frauds, as some other panelists also mentioned, see, if it is not within the domain of the independent director to uncover that layered fraud, or it does not fall in the definition of due care, then the law cannot punish it. So that fear cannot be there. But it cannot be that you accept the office of independent director and then you take it easy and you don't do the duties, because you are basically to perform the role of a vigilante. If you are not a vigilante and you start acquiescing or you think that board meeting is a formality or you are not required to prepare for it, It's not easy. Even as a shareholder, what I find is that you are served with voluminous papers nowadays. But how many of the shareholders go through it? Very few who are intending to either be present in the meeting or vote for a particular resolution. So it is that kind of a duty which is required to be performed, and which a person before accepting this office has to be ready. Now, the problem which I see from the discussion which has taken place is the harassment. Now, the harassment, you cannot say that I have become an independent director, but don't prosecute me because I am independent. Because if you have not performed your due care and diligence, the law requires that you should be prosecuted. The problem happens that the time taken to decide to whether he took due care or diligence, that becomes very long in our system. Now that is where the harassment comes in. If an independent director were to know that, all right, within the next 3 months or 6 months after a complaint has been lodged against me, I will be able to show that I took due care and diligence and I am not to blame, or I was not privy to what led to the fraud or any misrepresentation, then I am sure nobody would mind it, because when you take up anything, you take anything. See, it is something, when you take up an office, it comes with some liabilities always. You bring a child into the world, it comes with responsibilities. So you cannot say that I should be an independent director, but I should not have responsibility. So the need of the day perhaps today is to uh, uh, generate some mechanism in which within 3 or 6 months, a finding can be returned vis-a-vis directors who are so-called independent, whether they had any role in the offense which the company is accused of or not, and in which they as a director would be liable, or under a specific law under which directors have been made liable, where they would be liable. Now, what we have seen in recent past in the context of Commercial Courts Act, earlier in civil litigation, there were no costs of the length of time or the expense which you undertook. But now under the Commercial Court Act, the courts are awarding actual costs to the parties which wins, and when it finds that the other party has raised a dispute or taken time in the litigation unnecessarily. So that is acting as quite a deterrent for this kind of action. So for that also we can provide a system over here that the prosecuting agency or the department, a fund has to be created wherever it is found that it has roped in an independent director without proper care or without proper material, then the legal costs are awarded from that fund, or the officer who has committed the mistake, a part of his salary is forfeited for that. If it is a case of a private complaint, then of course the complainant would be liable. So according to me, these are the few things which need to be taken, but the thing is, the reason cannot be defeated. See, recently we saw there was a ban of firecrackers all over the country. Now, how do you, so that was also a mischief which was sought to be taken care of. So one of the suggestions which fell during the hearing from the Supreme Court was make the police commissioner liable. So the police commissioner was supposed to put a constable behind each individual who was capable of that mischief. So that is the reason. See, the vigilance could not be for each company which required care. So we have said, all right, appoint a vigilante, an independent director in each. So he has to perform his duties. If he is not performing his duties, he cannot be heard to complain that why I am being prosecuted. These are my thoughts on the subject. Of course, it remains subject to adjudication by the courts. Thank you.
Thank you so much. Very, very insightful. So what I petty take away is that there are no free lunches. So those
No
of us who
freelance. Absolutely right.
are thinking that let's join a board, so we have a lot of friends and clients who come that now, we're retired from business or profession or job. Can you get us some boards? So we keep on explaining to them that it's not that easy. You know, that you have to work and slog if you really want to go to a board today. It's not that easy.
Ideally, there should be a course. See, there
Yeah.
should be an examination like we have in some countries for realtors, that you should take that examination and you should take it periodically to see whether you are fit enough to be an independent director.
So, Rajiv, there is some exam which now has been introduced. It is
Okay.
not as strict as probably you will have in mind, but still, yes, you know, some beginning is there.
Yeah.
So let's see, you know, to what level it goes. But in fact, I also took that exam before I
Okay.
was inducted on the board. So there's some criteria where it's not required, but generally there is.
Yes.
So, in the interest of time, Sudarshan, can I jump to you straight away?
Yeah.
For one thing, which I'll probably ask everybody later on. Now, you know, one issue which even Dr. Bhasin raised was on the appointment of independent directors and how independent they are, because they're ultimately a choice of the management who come there. We know that SEBI came up with this proposal, which was shelved off, of this dual approval process. It was withdrawn in June 2021. It was welcomed by some people, not liked by some people, but withdrawn ultimately because of pressure. So, in your opinion, you know, what more can be done in the appointment? Is there something, some different tool, some different method which can be adopted?
Okay, first, Rajivji, there is a proficiency test. Okay.
Okay.
So it's a basic level test where you will have to pass the test to become an independent director, but that's nothing to do with the assessment of how an independent director performs. Okay. Now on this dual approval, Rajesh, I think it was withdrawn because it was a flawed one, to be very honest.
Yeah.
Because there were too many complications out there and the timelines that SEBI had set was not practical at all, so they have withdrawn it. Okay. Now coming to this question on this promoter related appointments of independent directors, I think this question which you are asking is in light of Z Invesco, Majestic Auto, Dish TV, Dhanlakshmi Bank, you name it. I can just go on and on with the cases. But yeah, so basically Z Invesco was minority shareholders' request to appoint some directors. Whereas Majestic Auto is a lovely case where the promoter wanted 5 independent directors of his own. So understand the guts, which is actually in corporate India today, India Inc. What is happening is they are openly going and recommending independent directors of their choice. So it is happening. So this question is very relevant. Okay. Now, to be very honest, we should understand that shareholders don't actually own the corporation. Okay, they own only the shares of the corporation. I think this is the biggest misnomer which is happening. So the corporation owns itself. So that's how the whole thing comes up when you are deciding on who the promoter as a shareholder is. Now, very good initiatives. What is happening to curb these provisions of promoters trying to get their own people on board? Proxy advisory firms are playing a great role in India today. Shareholder activism is playing a great role in India today. These are all some of the big plus. Okay. Now, these are keeping the checks and balances. Now, SEBI is doing reasonably good by levying lot of strictures and all that on independent directors. So the independence of the independent directors is very quietly monitored by the institution called SEBI. So that is also good. Now, please understand, if you have to ask more policing, it is not possible because all that is left is self-regulation. So, how much ever a promoter would want to induct their person as independent directors, it is the independent directors who have to exercise self-regulation. That's the only thing which can save this institution called independent directors. Okay, now, very importantly, you should understand why this question has come up. Today, what is happening is independent directors are seen to be prime witnesses to stealing of money by promoters. Okay, if you want some case laws, SREI infrastructure, ILFS are classic cases where independent directors were held witness when promoters were swindling money. Okay. Okay, these are all printed in the media, so don't. I've already given my disclaimer, so it's okay. Yeah. The second one is independent directors are seen to be consenting parties to conflict of interest. which is again, oh, there are zillion cases on conflict of interest. Latest is Vedanta, which SEBI hauled up. Prior to that, it was Indigo. There are so many cases. So what is happening with the institution of independent directors? They are seen to be consenting to conflict, which means they are actually towing the promoter's line. And of course, 3 points. Again, I'm not going into too many points, just three points. IDs are seen to lack behavioral skills inside boardrooms. Now, this is another big one. Now, I'm only giving you 3 points, Rajesh, which is justifying the cause why you are asking me this question. On why is it seen that independent directors are people who are placed by promoters inside boardrooms? Yeah. So these 3 things, one is witness to stealing, number 2 is conflict of interest, and third one, of course, is the behavioral skills. Now, for behavioral skills, I would love you to look at Infosys as a case study where CII played an amazing role as a chairman. It's one of the brilliant case studies in corporate India where one director, the chairman, who held on to himself, his vote, his independence against the promoter's wish, which is a beautiful case, which is Infosys. Okay, so these 3 are things what makes you ask me this question pertaining to independent. Now, is it possible for MC or SEBI to intervene in all these cases? No, it is impossible. Please understand, whether it is Indigo, whether it is Z, whether it is Infosys, I think the regulators have better job to do, and it is only the job of independent directors to get on to the job of sorting out the internal problems. So now, to answer the last part, how can we improve this whole concept on independence? The first takeaway is, I think independent directors should get on to the speak up culture, which is lacking, from my perspective, from analysis of cases, speak up culture. Okay, however powerful a chairman is inside the boardroom, I think the independent director needs to get his guts up to say, just give me a minute, I need to express, instead of his voice being suppressed. The second point is, there should not be interlocking of boards. Now, PMC Bank is a beautiful case where the chairman Wadhwa was the same chairman who was in DHFL, and all the money was siphoned off from PMC Bank. 7,000 crores was siphoned off from one bank to a public company, only because it had a common chairman. That's the biggest problem on independence. The third thing, which is very important, is I think independent directors have to protect the minority shareholder interest. Now, what is happening is, whether it is Z Invesco case or whether it is Tata Sons case, I think as an institution, they are failing. So I think there is something going wrong in the system. I don't know how they will really buckle up. Of course, Z Invesco, I would not say it's a total failure, because here the independent directors played their cards well. And what has happened is, the beauty is, they really lived in the letter of law, not spirit, letter, which is Z promoters were the minority shareholders compared to Invesco. Because Invesco was holding 12%, Z promoters were holding 2%. On a very light note, I'm just saying. So independent directors played their role well in Z Invesco. Okay. So this is what I want to offer as a takeaway, how we can try and get these boards to act properly. And of course, the most important thing, Rajesh, is if you can't do any of these things, I have been telling this over a period of time, let the regulators institutionalize the institution of independent directors. Let them give a red beacon ambassador card. Sorry, maybe you can upgrade it to some lectures or whatever, but give them a car with a red beacon. I think that will solve all problems. Let the government own up these independent directors as babies, empower them, give them an undersecretary status. You will see India changing completely. But is that where we want to go? I leave it with that particular question over there.
Thank you, suggestion. It cuts both ways. It's a very dynamic suggestion, though. But from legislature to the current suggestion you make, I don't know what is right, wrong. So we have a judge who can probably comment better than what I comment on this.
I know.
So, but I know that there's some questions. I see that a lot of questions stand answered already by our esteemed panelists. But one question, Shailesh, I may come back to you, is on the crisis management. Do you think independent directors can play any role on crisis management if there's a crisis, the real crisis in the company?
Oh, absolutely. I feel it often falls upon the independent directors, and I'll give you 2 or 3 instances. If you recollect, there was that exotic derivatives situation that arose a few years ago, and many companies were defrauded of, in this particular company that I'm thinking of, 100 crores in an in exotic derivative. So it was the independent directors who were made in charge of making the public disclosures, of going to SEBI, of monitoring the investigation, of making sure that what punishment needed to be meted out to the miscreants were actually meted out. In this particular case, the person who committed the fraud, if you like, or committed the situation that led to this loss was very close to the management. And it took the independent directors, with the support of the rest of the board, to make sure that the punishment was meted out, the situation was corrected. Therefore, in a crisis, it is critically important to bring the independent directors to the front line. In many other situations where there are disputes between promoters, where there are situations of very rapid unraveling of a business model, or the commitment of a very large fraud against the company. In all these instances of crisis, it is the independent directors who should come on a less intense basis, even for things like choice of long-term accounting policy, choice of making sure that the implementation of an ERP or of a cybersecurity program or of a new ERM program. Often, independent directors are brought in to provide their expertise and their independent view. I would only like to add one point to the appointment debate, which was very, very, very well conducted, that the Nom-Rem committee now has been strengthened and empowered considerably. And the entire succession planning for independent directors also has now become the remit of the Nomination and Remuneration Committee, which I think is a very good input that SEBI has made very recently to strengthen the whole practice of how do you appoint independent directors. And as a result of that, there has been great objectivity that has come into the process in terms of a whole pool of people getting actually created who could potentially be good independent directors in a succession planning mode are identified up front, both with the help of external consultants and through processes which are led by board members, current board members, to make sure that a nice cohort and pool of directors is available from which the choices could be made to establish what I like to call an appropriate DNA of the board.
Okay, very interesting. And I think in our experience today, all the important committees are led by independent directors. Today, they chair most of the committees which are important, including audit and all that. So I think those fundamental radical changes are coming, and hopefully, this office is going to perform a little better than what it's performing today. But Justice Enlow, you heard Sudarshan. So there is a debate which I also hear most of the time, whether the appointment of director should be, say, through a government-nominated body agency, or the choice at least should be given to the management, later on ratified by the shareholders in the shareholder meeting, etc. All those processes are there in place now. But fundamentally, to empower the independent director, the way Sudarshan said, or the other suggestion that the appointment itself should be controlled by the government. Would you like to share any of your thoughts or views on this?
You're
Sir,
on
you are
mute.
muted. You are muted. Sir, you have to unmute.
I am not competent or qualified to speak on the subject, but what immediately comes to mind is, see, we've had these clauses in the financing agreements since ages about the banks appointing the nominee directors on the board. But that never bore any fruit. Of course, again, subject to correction by the experts we have over here. That did not prevent the accounts from going bad, or that did not make the nominee directors report anything to the bank which had nominated them. In fact, most of the time, when one saw in the litigation, they were not even participating in the board meetings. So I would be a little loath to have a department of independent directors created, because according to me, that would come with its own negatives in the system. So we have professionals, we have headhunters for professionals, and once we have a well laid out charter about these independent directors, I'm sure it would become a profession. See, and let us make it more remunerative. When, as you will know, when we joined the profession of law, we were always told that just because you feel the client has not paid you enough, don't go and make a mess of his case because it's your own reputation. So that should not be the reason. So if it has to be more remunerative, make the companies remunerate appropriately so that it is well worth a profession to become an independent director. But it should be left, and maybe one thing which can be done, see that one of the provisions says that the company will provide the criteria for what criteria, depending upon the industry which it is dealing in. So maybe those conditions can become more strict. Somebody, the criteria should be somebody who would understand that industry. Because see, independent director now, once they have a certain proportion, they should also be coming to the aid of the company. They should help the company and make more profits. One criteria, of course, is that they should act as watchdogs. But once they are on the board, their acumen should also be used to contribute to the profitability of the company. So I'm sure professionals, we heard Mr. Haribhakti is there and how much he contributes on the various boards. So I'm sure there will be others who would be keen to take it up. And inshallah, we will have some universities take up this aspect and maybe law colleges to train people in the same.
Yes, thank you, Rajesh. Yes, thank you. Thank you. Before, I see a lot of questions, but we have limited time. So I don't know how to handle these so many questions here. But Dr. Bhasin, would you like to, you heard all of us now. So would you like to make some concluding comments? And Vikas, over to you if you wish to say
You can
something.
direct all the questions to Dr. Bhasin.
So Vikas, would you like to say something while concluding? And Dr. Bhasin, would you like to have some concluding comments?
Sure. So no, I think this is very insightful and very interesting and engaging discussions over diverse because we have the judiciary, we have the professionals, chartered accountant, company secretary, and we also have the legal practitioner. So it's a diverse view which we have heard in last 90 minutes time. So the one message and one thought which I got is that to absolve the liabilities, I think recording of the dissent is the most important thing where an independent director can safeguard in terms of potential sort of liability. So recording of dissent is one of the most important thing which should be done by an independent director. That is one. Other point which I thought that maybe discussed and maybe we can take it for another session is that independent directors in PSUs, because that is totally different ball game. What we have talked just now, the laws are same, but the practical aspect of an independent director in a PSU is totally different. So that is something also we may have to look into, especially from a CII perspective. And another point is that we have talked about the law, but is the law matured enough in the country, A, to encourage professionals to take independent directors, not to have the fear of in mind of the independent directors that if something goes wrong, and the example of the ex-SBI chairman, which has been quoted out here, which is very, very relevant and very important, and probably it is giving a wrong precedent to the overall independent director profession, whether they should opt for independent directors position or not. And second is that is our law matured enough to distinguish the fine balance between the point which was raised, corporate frauds vis-a-vis corporate governance failures? Because in terms of the liabilities, in terms of the penal legal consequences, it's a huge difference. But in terms of our law, whether to segregate that and then take the right legal course of action in really identifying those malpractices or governance failures, I think that is also the issue which maybe we can take more time to debate on. And also, Justice Anlaw narrated a very insightful quote, but there are two quotes also which are being made by one of the business leaders of the country. One is that God we believe in, but it is the data or numbers we trust. So that is also very important. And another is that when in doubt, disclose. So I think it is more coming back to the ground reality or very simple calculation that one asks if one complies in true letter and spirit, or if there is a self-governance or self-conscience in mind, then I think half the battle is won, and then we can take care of these issues. So these are some of the observations which I thought that.
Thank you, Vikas. So nice.
Thank you, Mr. Vikas Mohan. I think it was a wonderful session on very important topic. To sum up, my personal view is that there needs to be a change of the mindset in the business leaders, in the business community. And if there is a change in the mindset and there is adherence to the principle of good corporate governance, then this issue becomes academic as to what role should be that of the independent directors and whether they are. Therefore, it has to be a 2 or 3 pronged initiative taken by the corporate world itself. Nothing, government can't do anything. Independent directors by themselves can't do anything. So there has to be a change brought about by the corporate world itself, that there should be good adherence to the corporate governance practices. If we adhere to those, then all these issues, you see, would essentially and mainly not arise. Yes, sporadic cases would be there. Exceptions are always there. Fraud will always be there. Scams will always be there. But at least there should be an attempt to have good corporate governance practices. And that is where institutions like CII and other chambers of commerce, they can take the lead in, I would not say educating the mind of the corporate leaders, but at least bringing home to them that what is required, you see. I think a last word, if it can come from Mr. Shailesh Hari Bhakti, he's like a leader in this field.
No, sir, I completely endorse your view on mindset change. But I think it is also important to get to what Vikas said a little earlier on data led and evidence led performance at boards. But most important, I think we need to digitalize massively all processes, whether they are accounting, auditing, board governance, compliance, legal, all of these areas need to be blockchained. And we need to harness the power of quantum computing to bring about that complete transparency and that complete sense of comfort and trust that we can carry on the risk taking and the innovation that we must do. As I said this afternoon, next 6 months we'll see much more innovation than we've seen in 10,000 years. To prepare for that challenge, we need all this empowerment and all of this technology enablement. Thank you very much, CII.
Thank you.
This was a
Thank you, Rajesh ji.
absolutely
Thank
wonderful. Very
Justice
well conducted.
Anglo, for your presence. Thank you, Ranjana. Thank you. And
Thank you. Thank you,
Lalit bhai.
Jagdish, Justice Andlaw, Sundareshan, Ranjana, Mr. Rajesh Gupta for moderating this session. Thank you all for your time, and we really had a wonderful session. I think this is one of the most interesting and enlightening sessions which we had on independent directors issue, and we look forward to continue the discussions and have another session on many more issues which are of importance and relevance to through this subject. So thank you for your time, and of course thank you to Dr. Lalit Bhasin for guidance and for leading this initiative for CII. Thank you very much. Thank you all.
Thank you, sir. Thank you very much. Thank you.